Hear ye, hear ye. The Court of Appeals for the First District of Texas is now in session. Pursuant to adjournment, God save the Constitution and His honorable court.
Good afternoon and welcome to what we hope will be the last virtual oral argument in the First Court of Appeals for a while. We have one case on today's docket, case number 0121000422-CV, City of Houston versus Kathy Denby. And we have the appearance of counsel for the appellant, please.
Christy Martin for the City of Houston.
And for the appellee.
Jill Schumacher on behalf of Kathy Denby.
And you've both been allotted 15 minutes. Ms. Martin, do you want to reserve some time for rebuttal?
Yes, please. I'd like to reserve 5 minutes for rebuttal.
5 minutes will be reserved, and that's why the clock now says 10 minutes. So once Ms. Schumacher is escorted off the Zoom screen, Ms. Martin, you may begin.
May it please the court. This case arises from the unprecedented public health emergency of the COVID-19 pandemic. Circumstances that were so unusual that the Texas legislature took steps to pass legislation that not only became effective immediately upon the governor's signature on June 14th of 2021, but also was retroactive to March of 2020. I would like to spend the majority of my argument time discussing the pandemic legislation, but before I get to that, I would like to briefly discuss two other issues. The first being the tangible personal property waiver under the Texas Tort Claims Act. As this court knows, there are two waivers of governmental immunity in the Texas Tort Claims Act. One of them is the tangible personal property waiver under 101.021.2 of the Civil Practice and Remedies Code. The Texas Supreme Court has recently made clear that in order for the tangible personal property waiver to apply to waive governmental immunity, the government itself must be the user of the property. And in TDCJ versus Rangel, the Supreme Court said it's not enough for an employee to have access to tangible personal property or to be generally authorized to use that property. The only time the government itself uses that tangible personal property is if the government contemporaneously authorizes or orders an employee to use that property in the circumstances that are the basis of this suit. What we have here is a judicial admission by Ms. Denby that there was no contemporaneous authorization. This case stems from a striker stretcher that overturned carrying a patient towards an ambulance during what we thought at the time was the height of the COVID pandemic. There was no contemporaneous authorization for the EMTs during that transport to use that stretcher with that patient in this circumstance. And without that, there is no waiver of governmental immunity. And this interpretation of TDCJ versus Rangel was confirmed last summer after we filed our motion for summary judgment on this issue by Judge Lee Rosenthal of the Southern District of Texas in Chavez versus Alvarado. So the second issue I want to flag for the court is the 911 exception. As the court knows, the Tort Claims Act has the initial waiver provisions and then has exemptions and exclusions that vitiate the waiver of governmental immunity, basically reinstating immunity that would otherwise be waived under one of these waiver provisions. And what the one at issue in our motion for summary judgment was the 911 exception. Last week, the Texas Supreme Court issued a couple new decisions involving the Tort Claims Act, one of which addressed a different exception that we really didn't move for in our motion for summary judgment. That's the emergency exception. So the 911 exception is in 101.062 of the CPRC, The emergency exception is in 101.055 of the CPRC. And the recent decision on the emergency exception has implications here because there's similar language in both exemptions under the Tort Claims Act. So in City of San Antonio versus Maspero, the Texas Supreme Court held that, again, plaintiff bears the burden to overcome the exception. And then it also held that for the provision that says this chapter doesn't apply to a claim arising from the action of an employee while responding to an emergency call or reacting to an emergency situation, if the action is in compliance with the laws and ordinances applicable to the action, or in the absence, if the action is not taken with conscious indifference and reckless disregard. To prove that, the plaintiff must establish a causal nexus between the statutes that were violated and the plaintiff's injuries. So the similar language in the 911 exception in 101.062B says this chapter applies to a claim against a public agency that arises from an action of an employee of the public agency or volunteer under the direction of the public agency, and that involves providing of 911 service or responding to a 911 emergency call only if the action violates a statute or ordinance applicable to the action. So missing from 101.062 is an alternative for conscious indifference and reckless disregard. But both—
Martin, let's just turn to the issue of Senate Bill 6. And if I understand you correctly, we don't need to reach or interpret Senate Bill 6 in order to find immunity. We can rely on the 911 exception.
Agreed, yes.
So we don't need to be the first court to write about Senate Bill 6.
Agreed.
And just as long as we're talking about Senate Bill 6, how was, and if you could, with record references, can you tell us how the COVID-19 pandemic was a producing cause of the injuries to Ms. Denby?
Yes. At the very beginning— I'm sorry?
Sorry, I corrected myself on the name. So
Okay. The whole reason an ambulance was caused in the first place was because the allegation in the original, in the interrogatory responses indicated that the Denbys were afraid when Mrs. Dot, the decedent, started experiencing breathing difficulty. She would not get immediate care if she was not taken to the hospital in an ambulance. And it was all because of the COVID pandemic.
except we have the, when we're talking about producing cause, that's different from proximate cause. But the pandemic has to be a producing cause of the situation. It seems like here, at the very least, we have the intentional acts of Mr. and Mrs. Denby in deciding to call 911 because of some apprehension that they had. And does that sever the cause of the causal relationship between the pandemic and Ms. Denby's injuries?
I don't think so, no. Because we have to go back to the language of Senate Bill 6. It's not narrow. It is a very broad statute. The pandemic or an emergency disaster declaration related to the pandemic disease was a producing cause of the care, the treatment, or failure to provide care and treatment that allegedly caused the death or injury. It's broader than just the actions in response to the pandemic that are the tortious actions at issue were the producing cause of the injury. It's broader than that.
I mean, in addition to the actions of the Denbys caused by the pandemic, weren't there also changes in the rules that the EMT personnel observed in terms of their proximity to the patient and how many of them could participate, all caused by the pandemic? That
is absolutely correct. Just weeks before this incident occurred, the Houston Fire Department changed its patient care guidelines that were put in place to balance the needs of getting care to people who need care, at the same time protecting our staff from the pandemic disease, conserving PPE, because you got to remember, back at that time, everybody was afraid we're going to run out of N95s. And we were suffering staffing shortages because so many people were getting sick. And at the time, the guidelines for quarantine were 14 days or more. So yes, those patient care guidelines required EMTs to limit their exposure to patients to one person within the 6-foot bubble. And only that person was allowed to wear a mask. Everyone else was just to wear goggles and I think gloves, just to conserve resources and protect our own staff.
Are there any more questions from the panel? Thank you, Ms. Martin. Now we'll turn to Ms. Schumacher for 15 minutes.
May it please the court. Mrs. Elizabeth Dott was in stable condition when her son-in-law called 911. They expected for her, she's having breathing issues. They expected for her to go to the hospital and receive treatment. But everything changed once the EMTs arrived. They carelessly wheeled her on a stretcher, violating their duty of care. The stretcher tipped. Mrs. Dott was strapped to the stretcher, unable to break her fall, and she died. The city contends that there should be no consequences for actions like this, but we're all safer. Yes, Justice Garrett.
Where do you get the duty of care from? Where does that's breached in this case?
The duty of care is a legal duty. It's implied from Texas Health and Safety Code 773.009. Because Mrs. Dott was strapped into a stretcher in the care of the EMTs, at that point, they had a duty of care to transport her according to the safety guidelines for operating the Stryker stretcher. All right, I'll first address the 911 exception. The 911 exception, as was discussed earlier, reinstates the city's immunity in certain circumstances, but it doesn't apply if the EMT or governmental unit has violated a statute or ordinance. The city's arguments that they have immunity fall in two general categories. The first is sort of an application sort of category. The city says that because the statute doesn't explicitly contain an affirmative duty, it wasn't possible for the city to violate the statute. And then the second category of arguments are policy arguments. There's no binding authority that says that a statute needs to explicitly have an affirmative duty to be capable of being a statute that can be violated. And we see several, and it would in fact be a quite novel holding for this court to hold that it's impossible to violate a statute simply because there is no explicit affirmative duty. Think about the city's attorney just recently was addressing the other emergency exception, 101.055. Texas Transportation Code Statute 546.005 is a statute that is regularly used to overcome the emergency exception. That statute is structured very similarly to our statute. Chapter 5. Yes, Justice Goodman?
What is the violation though that you're pointing towards? What did they violate?
So the statute requires operators, they're subject to liability if they don't operate with an ordinary, according to the ordinary standard of care. And operating the stretcher in the elevated loading height instead of the lowered transport height caused the center of gravity on the stretcher to be higher, which caused it to tip when they wheeled it down the driveway. The other violation, yes, Justice Garrett?
Oh, I'm sorry, go ahead and say what the other violation is, please.
The other violation is that the standard of care required them to transport the stretcher perpendicular to the driveway with the patient head to foot. that reduces the surface area touching the lid of the driveway at any time. Instead, they operated the stretcher, they rolled the stretcher parallel to the street, which also caused it to tip. Those two actions violated the duty of care and also didn't comply with the guidelines and the safety recommendations for operating the stretcher. And yes, Justice Garrett?
Well, I was going to ask you, what's your best case for those two, what you're calling violations of the statute?
I would like to submit a further brief on that point. It's general standard of care in Texas law requires, and we have an expert report discusses this in depth and how this violated the standard of care in our situation. It's unique to our situation. We have an expert who says that in this context, the standard of care required the EMTs to operate the stretcher according to the safety guidance and the guidelines presented by the manufacturer. And our expert explained that this is a breach of that standard of care. And
wasn't one of the issues the number of EMT personnel who were handling the stretcher, that you were suggesting there should have been 4 or 5 of them instead of 2 of them? Is that right?
Well, the evidence shows that there were 4 EMTs surrounding the stretcher. That's at Parks Record 123. In his report, Mr. Everlove stated that if the EMTs felt that they could not safely operate the stretcher with the number of personnel that they had, and I believe there were 6 EMTs at the scene, then they should ask for help. But
weren't they subject to the requirements not to have more than 1 EMT with a mask in that area?
The record shows that they weren't following those requirements. There's no evidence from the city stating that the first EMT order the city cites says 1 EMT should initially approach a patient within 6 feet and then make an assessment. And if more EMTs are needed, they ask for more help. That's what the March Houston Fire Department order states. But additionally, even if the orders were as the city contends they were, the record affirmatively shows that the EMTs were not following those orders. So there's no evidence that those orders, there's nothing in the record, no affidavit, nothing that says that that order caused any city employee to act differently in this situation.
Go back to the relationship between 101.062 and 773.009. So 062 says it says it'll be liable only if it violates a statute or ordinance applicable to the action. So it says if you violate the statute, you will be liable. 009 is phrased in the negative. It's almost phrased like a safe harbor. You're not going to be liable if you are in accordance with the standard of ordinary care. So how is, one thing if 009 said is liable if they breach the standard of ordinary care, but it's phrased in the negative. So how is that a violation? It's phrased as a safe harbor, not as creating a statute that can be violated. So how do we reconcile those two differences, that difference between the 2 statutes?
Well, across Texas jurisprudence, there are several similar statutes that are interpreted as being capable of being violated, even though they're phrased in the negative. For example, Texas Transportation Code, section 546.005, and the 14th Court of Appeals just addressed this particular statute last month on January 11th in their opinion, City of Houston versus Green, which is 14-20-00190. That statute is similar. Chapter 546 of the Texas Transportation Code says, if you're an emergency responder operating a motor vehicle, there are certain things you can do, including speeding. But the statute that's cited to overcome the exception, 546.005, simply says this chapter doesn't relieve a responder of any duty of care or of the consequences for reckless action. There are other statutes within Texas jurisprudence that have a similar effect in a case, regardless of the, in spite of being phrased in the negative. And it's still implied in the language of the statute is a requirement to operate with a duty of care, because that's the only thing, there is liability for that sort of operation. And a statute can be violated even without an explicit affirmative duty. So there's the Texas Transportation Code 546.005 to look at, and the jurisprudence surrounding that statute. It's almost identical in the way that it's structured to our statute. But there are other statutes throughout Texas jurisprudence that are similarly worded negatively, but they do things that create a cause of action. The city also has Justice Kelly?
Is Green your best case on that point?
Yes. The city also makes a policy argument that the 911 exception just shouldn't count as a statute because it relates to the duty of care, but there's no inconsistency between Texas Transportation Code 773.009 and the 911 exception. The city's immunity does not become hollow if you apply this statute, and that's because the city still enjoys benefits because of the plaintiff's burden to plead and prove the violation. They still have the ability in an early phase in the lawsuit to move for summary judgment on this jurisdictional issue. I'd next like to move to if there are no further questions on the 911 exception, talk about tangible use. The city's immunity is waived because they used personal property in this case. The plain language of the statute and this court's precedent, the Kennedy case that we cite in our brief, explain that use is to employ property for its intended purpose. In the NAB case, the court had to deal with a situation where there was an off-duty employee using property issued by a governmental unit in a way that the governmental unit did not intend. In fact, that employee was criminally charged for the conduct. A NAB created a rule that if the property should not be used at all in a given situation, if the government has that policy, then the governmental unit cannot be responsible. Wrangle is an exception to the NAB rule. It doesn't further extend it. In Wrangle, the governmental unit had a policy that a certain type of ammunition should not ever be used indoors. But because the government employee was considering using the property indoors and they went and deliberated about it and discussed that with other authority figures within the governmental unit, the Supreme Court of Texas said that the government is liable in that case where they specifically authorized the use in a specific situation. Now, the Chavez opinion, and Wrangle doesn't say that that a general authorization is not sufficient. The Chavez case by Judge Rosenthal is a similar situation. In that case, there was evidence in the record that the employees were not to use their weapons in that particular situation. In fact, the governmental unit placed those employees on administrative leave. And so what that opinion is saying is if there's no authorization or intent, then there's no use. But in our case, the city was using the stretcher just in their ordinary course and scope. Adopting the city's interpretation in this case would be a significant change and a significant expansion of the statutes. And even the case that the city cites for the 911 exception, the Schwank case, is an example of use of tangible personal property without a contemporaneous authorization. Next, I'll talk about Senate Bill 6.
Specifically about Senate Bill 6, just following up on the question that Justice Kelly asked. Basically, he asked if we agreed with the city on tangible use or on the 911, we never would have to look at Senate Bill 6. In your case, though, even if we agreed with you on tangible use and 911, you would still have to prevail on the Senate Bill 6 argument, correct?
Yes. Yes, we would. But we do prevail on that argument. Senate Bill 6 is worded, it states that the disaster declaration needs to be a producing cause of the care, treatment, or lack of treatment. And then the statute in subsection D defines what care, treatment, or lack of treatment can be. And it has 9 enumerated subparts. Then the city has, the record in this case affirmatively shows that the city was not in compliance with any disaster declaration. The city says their position is that they were only allowed to have 1 EMT surrounding the stretcher, but the record affirmatively shows that they were not following that. And there's no affidavit or anything in the record that suggests that they were, or that there was any kind of, that declaration had any impact on the situation on the ground. So Senate Bill 6 is not applicable. So in some.
Can I ask you just one question
yes.
about that? I thought there was testimony that the people called for 911 because of the problems they expected to encounter if they did not arrive at the hospital in an ambulance with a patient having breathing problems. And that the reason for calling the ambulance and the EMTs was specifically because of the pandemic.
Yes, Justice Goodman, but the statute is a bit more narrow than the city suggests. The statute says that the disaster declaration or the pandemic has to be a producing cause of care, treatment, or failure to treat. And then the statute defines what sort of things can be defined as care, treatment, or failure to treat. So there has to be a link between the pandemic and the actual treatment. And the Denbys calling 911 because they were concerned about getting a treatment faster doesn't relate to any of the things that are defined in the statute as care, treatment, or failure to treat. I see my time is up.
Any more questions from the panel? Thank you, Ms. Schumacher. We now will return to Ms. Martin for rebuttal.
Thank you. I'd like to start off by discussing City of Houston versus Green. I'm also lead counsel on that case. So I did want the court to be aware that we did file a motion for rehearing on that case. And that decision was issued and the motion for rehearing was filed prior to the Texas Supreme Court's 2 decisions last Friday on the 2 issues that were briefed in that case. So that case involved the TTCA's emergency exception and official immunity. Last Friday, the Texas Supreme Court issued City of San Antonio versus Maspero and City of San Antonio versus Riojas. Maspero talked about the emergency exception and Riojas talked about official immunity. So the precedential value of Crystal Green has a giant question mark behind it. So it's probably not going to be good law for very long. I did want to touch on one of the questions raised about by Justice Guerra, I think, where does the duty of care come from? And that's the big problem here, because the duty of care is vague at best and was derived in part maybe from the Houston Fire Department's pre-pandemic patient care guidelines. That was what their expert allegedly relied upon in establishing the standard of care. And by July 6th of 2020, we all know that things changed significantly. So relying on pre-pandemic standard of care without addressing the changes caused by COVID is not going to be appropriate. And it went so far, and we put this in our briefing, that counsel during the summary judgment hearing represented to the trial court that we've chosen to ignore the effect of the pandemic on the standard of care. We're just not going to make a big deal about that. And that is not the way the standard of care works in the healthcare liability context.
So how do you respond to Ms. Schumacher's argument that those new pandemic guidelines were not being followed in this actual case where there were multiple EMTs in the area and that responded to this incident?
If I understand what counsel was referring to, being the record shows that these criteria were not being followed, there's a single photograph from the summary judgment record that reflects maybe after the stretcher tumped over that a few people moved in to make it upright. There was no other suggestion in the record that multiple ambulance personnel were within the 6-foot bubble prior to that moment. So the best response I can say is the photograph of a snapshot in time does not establish that the EMTs were throwing caution to the wind and disregarding the patient care guidelines. The photograph reflects
Can I
that.
ask a follow-up question about that, please? So, so assuming that, and because we don't have a photo, that there was only one EMT person pushing the stretcher down the driveway, but there were multiple who came to lift up the stretcher and the patient who fell, why was it okay for multiple people to be there at that point?
I don't know that there's anything in the record that says why it would be okay or not okay. The best I can tell you is when you see something bad, go down, sometimes we forget and your instinct is to do what's in the best interest of the patient to pick them up. And perhaps that was something that just everybody forgot about the patient care guidelines at that moment.
But then why was it that, so I guess I'm a little confused about if there is such a standard of care that the stretcher should have been in a lower position when it was being wheeled down, and if that's a dangerous situation, then what kept multiple EMTs or more than one from pushing her down the driveway in the manner that the plaintiff suggests?
My time is up. Can I answer your question?
Please.
Nothing prevented anyone from really doing anything other than the patient care guidelines that we know about. The EMTs could have disregarded those patient care guidelines, and perhaps that could have led to different or other problems. But the patient care guidelines are the only thing in the record that we have to talk about what should or should not have been done in terms of the pandemic, because plaintiff never produced any sort of standard of care on what we do during the pandemic. I see my time is up, so unless there are any other questions.
Thank you for your argument, Ms. Martin and Ms. Schumacher. Cause number 0121004222-CV, City of Houston versus Kathy Denby is submitted, and the First Court of Appeals is adjourned. Thank you.
Thank you.
Thank you.